My name is Rachel Krasner. I'm the Director of Career Services, and we're pleased to have this program. And I want to also thank Professor Armour for hosting and also helping the school sponsor lunch for you. So always a nice thing. Thank you. And without further ado, because you don't need to hear from me, I'll turn it over to Professor Armour. Thank you.
Thank you. Larry Krasner. It's been a minute.
It has been.
You know,
wonderful to see you again.
I've been following you closely. Miriam Krinsky and you went overseas to visit some places that have different approaches to criminal justice. I hope for us to get into that more soon. The last time that D.A. Krasner was here last year around this time, he was kind of a newbie. You know, you're new to the office, relatively, and we'll get to talk some about your experiences since the last time we talked this past year. Since there are a lot of 1Ls here who may not know why I have a particular connection to the DA's office and the DA's story, let me give you a quick, very brief, you've already heard this from last year. Let me give you a quick account of how it is that I came to think so hard and long about the importance of the DA's role in criminal justice. I was introduced to the majesty of the law at age 8 when the door to our apartment unceremoniously parted company with its hinges. It was kicked down and a phalanx of officers came in, arrested my dad, shackled him, and the next time I saw him upright was in the Ohio State Penitentiary, where he was convicted for 22 to 55 for possession and sale of marijuana. The case of Armour versus Salisbury is one that he actually appealed on his own, pro se, as a jailhouse attorney. He had to teach himself the law. Got the warden's own law books first, teach himself criminal law, criminal procedure, constitutional law. Then wrote his own writs of habeas corpus, represented himself up through the state system and through the federal system. And I was standing with him as a 14-year-old in the Sixth Circuit Court of Appeal before an en banc panel of judges as he was literally arguing for his life. And the basis of his claim to redemption was that the DA in his case violated the due process clause of the Constitution by telling the jury that the DA had not cut a deal with the only witness against him when the DA had cut that deal. So the court said that it's a violation of a defendant's due process rights to lie to the jury in order to secure a verdict against the defendant. The attitude back in those days was in the DA's office, as in too many DA's offices, still just win. It doesn't, a morality of means didn't really make that much difference. So he prevailed in his case, Armour versus Salisbury, and I actually, those of you who have me for criminal law, will run across that case again as I teach Armour versus Salisbury in my criminal law class now. So it is kind of very personal as well as jurisprudential policy-based, my visceral connection to this old question of the DA and the role of the DA in our criminal justice system. D.A. Krasner, you came into office now more than a year ago, getting 75% of the voters of Philadelphia in the general election to vote for a DA who had been a public defender and a defense attorney, had never prosecuted a case in his life, and ran on the following platform: in cash bail, address police misconduct, and in mass incarceration, make deep cuts in mass incarceration. That was unthinkable 5 or 10 years ago. I could not have imagined, certainly 10 years ago, even imagine a DA running on that platform, let alone getting 75% of the voters to support that platform. So could you share with the folks here a little bit what went into your thinking when you put together that platform, number one, and then what have you been able to execute? Have you been able to find victories and make differences, move the needle in terms of your own stated goals and objectives?
Okay. Well, first of all, thank you. Wonderful to be here again. I am here to speak to you, but more importantly, I'm here fishing. I'm trying to bring back some 2Ls, maybe some 1Ls for the summer program, and I'm trying to bring back some permanent hires. This is something that Judge Temin, who's in the back row and is my first assistant, and also Yasmin Rosario, who is a sixth-year attorney with our office, are helping me do, and we are doing this in 30 different schools around the country. So I'm delighted to be here. It's such a wonderful institution that produces such great lawyers and sometimes people who have a really good time in the summer program. I'm delighted to be here. The platform was easy. It was the result of 30 years of being in criminal courtrooms in Philadelphia, which is a county, it is a city, it's the same thing. It's 1.6 million people, and it's a city where the people really have been stepped on by a criminal justice system that is racist, that is corrupt, that is incredibly punitive in so many different ways. So I didn't have to go to pollsters. In fact, I didn't have to really listen to other people telling me what I should believe. I had wasted so much time in courtrooms in Philadelphia watching things go the wrong way, and also some other courtrooms. I had been a federal public defender. I'd practiced in many different counties. I'd practiced in other states on occasion. But I had enough day-to-day contact that I knew what was wrong with the system. It just was not that hard to see. And it was mass incarceration. It was excessive sentencing. It was many things about the death penalty. It was the fact that the whole system picks on poor people, without question. You did not have to read the Brookings Institution study that I read recently, which says that if you are born into a household where the income is at the lowest end, meaning $14,000 or less, and you are then compared to someone born at the same time into a household where the income is at the highest end, which is not really that high, but it's $140,000 or more, then the discrepancy between your likelihood to be in jail at 30 years of age is 20 to 1. 20 of the people born into the poor household will be in jail by age 31 of the people born into the other household. So what we're talking about here is some very fundamental stuff about how justice is done and about the reality that the flip side of the coin of economic justice is criminal justice. They interconnect, they are related, and they're not related in the usual ways. That part was easy. Then you get elected, which was weird, but it happened, so there you go. Then you get elected, and what happens is you scare everybody by doing what you said you were going to do. And once you scare them enough, and once you get enough done, then they all wake up, and then they come after you, because the status quo doesn't particularly like when things change, and they don't particularly like, especially, when elected officials' incumbency is threatened. What we have become in Philly, and not just Philly, but in many other cities around the country where you have progressive prosecutors, we have become an existential threat to a lot of stuff that people are used to doing. In California, one of your strongest and most powerful unions is the Corrections Officers Union. Do you really think they're having an intellectual discussion about what they think criminal justice policy should be? Or do you think what they are doing is they dump tons of money into lock them up even more candidates? Do you think what they're really doing is protecting their own wallet or protecting themselves from the fear that things may change or they may suffer some kinds of instability? Let us understand, once you build this monstrous machine, that machine wants to keep driving down the road. It does not want to shrink. It does not want to decline in power and influence. It wants to keep on driving down the road. And that's just one of so many examples. You can have the judiciary disapproving of what you're doing because they're used to doing it a different way. You can have the probation department disapproving of what you're doing. You can have patronage as an institution in a big city disapproving of what you're doing. And you can have the mainstream party, even if it is the Democratic Party, disapproving of what you're doing because you're doing things in a fundamentally different way. So we have experienced that, and we've had a lot of success, but we also have had, a fair amount of frustration. And I think that we're going to continue to have a fair amount of frustration.
Great, Larry. I've had a number of students who are interested in public interest law work. The PILF Public Interest Law Foundation actually is a group that I've been kind of a staunch supporter of through the years. And the concern about folks who want to enter public interest is, how can I, in the enter public interest work in the office of a prosecutor? Aren't prosecutors kind of lock them up, kind of more punitive, not more concerned about their conviction rate than about doing substantial justice? And I remember you said last year that one way to look at a progressive prosecutor, although many have adopted that moniker lately who aren't progressive prosecutors, it's become more or less an empty buzzword.
Progressive prosecutors.
Yeah,
yes.
faux progressive prosecutor, progressive, I like that, prosecutors. You remarked that a progressive prosecutor, truly progressive prosecutor, is a public defender with power. And that resonated with me. That really struck home. Could you explain what you meant by that? And I think that can speak to a number of students who have a really kind of public interest bent, but really are trying to reconcile that with what may sound like an oxymoron, a progressive prosecutor, but obviously isn't.
Right. That comment got me in a lot of trouble, by the way. But I did say it for a reason. One of the reasons we go out recruiting is that we need to speak in order to explain what we are. There is a long-held and accurate perception of prosecutors as being all about charge them with the highest charge even more people, seek the highest level of conviction, maybe hide some evidence along the way. That is true. And it is also true that prosecutors historically around the country have been very much political animals who often took the position simply to run for something higher, which is even worse because it meant they didn't necessarily know or care what they were doing. They were out campaigning all the time, and mostly they were worried about the one thing they couldn't tolerate, which was a headline saying you took a chance on somebody and that person killed somebody, right? It is this weird space in which there is no downside to locking everyone up forever if you're a political prosecutor, but there's a terrible downside if people do what they're going to do, which is some of the time are going to commit crimes, no matter what you do, in terms of incarcerating them or not. So the reason I use the phrase public defender with power, and also the other phrase, which no one quotes, which is prosecutor with compassion, is because there is this middle zone in between those two extremes. The extreme where, the public defender is saying, Mr. Manson's not so bad, please send him home. He's misunderstood, a couple bodies here and there, tisk, tisk. And then on the other side, the prosecutor asking for the death penalty immediately right now, drawn quartering over retail theft. There is a place in the middle. And that place in the middle is not a weird place because the ethical obligation of a prosecutor, which is distinct from the ethical obligation I observed for 30 years as a defense attorney, the prosecutor's obligation is to seek justice. It's not to get elected to higher office. It's not to cheat. It's not to maximize your statistics that show you lock up everything that moves. It is to seek justice. Well, I think public defenders push very hard for justice. They don't have the same ethical obligation, but they're up against such unfairness on the part of the prosecution that in so many jurisdictions, they are the engine that pushes for justice. If, however, you envision the role of the prosecutor differently, as having an almost judicial obligation at the beginning of the case and at every step of the case to think carefully about what is justice. Do I need to bring this charge at all? Is it more just not to bring it? Do I need to bring that level of charge, or should it be something lower? Now that I've brought these charges, should this case be diverted? Is there a form of accountability that can avoid a conviction and thereby avoid economic disenfranchisement that's going to stop this person from getting jobs, going to school, getting an apartment, forming a family, supporting a family, right? These are decisions that are made at every step in the prosecutorial process. And if what you're doing is you're just a hammer trying to slam a nail all the way along so you can become a U.S. senator, then you're doing it wrong. You should be in that middle which is akin to a public defender with power, akin to a prosecutor with compassion who understands that the whole point is to do justice. The victory is not in winning every case or getting more years than the prosecutor sitting next to you. The victory is in achieving justice.
We've been so long addicted to this kind of retaliation, revenge, retribution approach to wrongdoing. And it sounds almost strange to some ears to hear restoration, redemption, reconciliation as even possibilities to put on the table. One of the places you see that most, that urge, that retributive urge to seek the most punitive possible sanctions is the death penalty. And I know you have done some extraordinary advocacy in Pennsylvania as a DA, talking to the courts about the Pennsylvania Constitution concerns with the death penalty. Could you talk a little bit about that?
So my connection to the death penalty goes way back, because when I was 23, before I went to law school, I was working as a carpenter after graduating college, and I ended up being selected to a death penalty jury in Pennsylvania, and I served on that jury in a very high publicity case, a sequestered jury, so I was actually sleeping in a motel with the other jurors at night as we came, as we made the decisions that we made. I will end the suspense by telling you the death phase never occurred, because one of our jurors was so psychotic, and I'm not making that up, that he was removed from the jury when he had a psychotic episode, and the defense attorney traded out the verdict of 11 rather than 12 for the prosecution dropping the death penalty. So we never got there, even though he was in fact absolutely guilty of a terrible rape, murder, arson. So that had a significant and formative experience. It was a formative experience for me. Before I went to law school, I focused a lot on it in law school, read pretty much every dissent William Brennan ever wrote about the death penalty, because they're brilliant and you should read them if you haven't. And then I came out and I became a public defender, and I have defended death penalty cases in many different instances, and I have had to make the decision as an elected prosecutor about whether we were going to pursue the death penalty, not only in the pretrial phase, but also in the post-trial phase. To date, we have considered every case carefully, and we have not pursued the death penalty in any case. The issue came to a particularly high boil recently, because some defense attorneys asked the Pennsylvania Supreme Court in a kind of emergent way to determine whether or not the death penalty as applied, I repeat, as applied in Pennsylvania, is unconstitutional. Meaning after the U.S. Supreme Court said, no, you can't do the death penalty, we changed our mind, yes, you can, a lot of statutes around the country were rewritten to comply with what the U.S. Supreme Court said in Furman versus Georgia about that. Pennsylvania statute was rewritten 40 years ago. Pennsylvania Supreme Court said, words look good, constitutional enough. But we are now back to Furman versus Georgia, where we're not just looking at the words, we're looking at what is the fruit of the tree. We looked at the tree before, now what's the fruit, to see whether, in fact, it is unconstitutional. So in order to do our duty, which is meet a deadline, take a position, we studied all of the death penalty verdicts that had come down in Philadelphia County over 40 years prior to our administration. And what we found is disturbing and caused us to conclude that, yes, it is the death penalty in Pennsylvania is unconstitutional as applied, because it is arbitrary. It is not simply punishing the worst people for the worst crimes. It is, more to the point, punishing not the worst of the worst, but the Blackest and Brownest, and the most mentally impaired, and the poorest, rather than punishing the worst of the worst. More specifically, we determined that death row is occupied 91% by members of racial minority groups from Philadelphia, and this is in a city that is currently 40% white and was whiter than that 10 and 20 years ago. We determined that as you look at how strong these death sentences are on appeal, 72% of them have been overturned by appellate courts. Let us understand that when you're a prosecutor, you're supposed to win on appeal about 95, 96, 98% of the time. What if you're winning 28% of the time? And not even 28% of the time, because the other 28% are still under consideration. This means that for decades, there have been prosecutors standing up saying, kill him, kill him, kill him, kill him. And 3 out of 4 times, relatively conservative appellate judges said, no, those proceedings were so unacceptable, those tactics were so impermissible that even our Constitution will not tolerate them, right? That is one lousy free throw percentage. That is one lousy batting average by any measure. That is just lousy and very, very concerning. As we dug into why so many of them were overturned, what we saw over and over is that the death phases lasted about an hour or 20 minutes, should have gone on for days, should have involved the production of records from education, from the Department of Human Services, from their criminal records, psychological experts, educational experts, neighbors who had observed what had happened to this young person all those years. They should have involved all that. They had none of that. Defense attorneys who got paid next to nothing came in and did next to nothing. And it was so unacceptable that you had 5 or 6 pages of notes of testimony where mom comes in and says, please don't kill my boy. And that is the entire death phase before a jury says, yeah, we're going to kill him anyway, right? So we saw that. We saw that over and over again, the psychological testing, the educational levels of people who had gotten a death sentence was quite low. We saw that the public defender in Philadelphia, which is rather capable, even though they're not paid great, but is rather capable, never got a death sentence in a homicide matter, and therefore was never found to have been ineffective on the death phase. But there was a small group of drastically underpaid defense attorneys, most of them hacks, to be honest, who had not only been found to be constitutionally ineffective in one death case, they had been found to be constitutionally ineffective in more than one death case. This is called ineffective assistance of counsel recidivism. That is not how a death penalty, which is the ultimate and the most severe penalty, is supposed to be administered. It is supposed to be the best lawyers, the best judges, the best process, and it's none of that. It is, in fact, picking on poor people, picking on black and brown people, and picking on people who are suffering either from mental illness or from low intelligence, other forms of intellectual disabilities. It's not what it's supposed to do. So after we saw all of that, we answered the legal question. Is it unconstitutional as applied? And the answer is yes, it is unconstitutional as applied. Whatever this machine you made, it's broke. And if you can fix it, you're going to have to do a heck of a lot. But as it is right now, it's unconstitutional as applied. Our Pennsylvania Supreme Court got all this good stuff. And there was another prosecutor's office that said, yeah, it's really bad, this death penalty, but it's good enough. That was their input. They got all this stuff, and they decided not to decide. So what can I say? Some of us are ready to take a swing at the pitch, and some of us are not. We'll see what happens down the road.
One thing, DA Krasner, that a lot of DA's offices are loath to do is revisit convictions. They are wins, and to revisit them may be to admit fallibility, and they are concerned that that may undermine their legitimacy. You seem to have taken a different approach, to have a different attitude about that. You're actually willing to look at some past convictions and see if real justice was served in those cases. Could you talk a little bit about that?
Sure. You know, the obligation is to seek justice. It doesn't say seek justice in the future. It says seek justice. So that obligation extends into the future. It extends into the past. Any DA's office has a massive number of cases under consideration where the trial is over, and you're trying to figure out, was it good enough, or is there some sort of a problem? We have had 10 exonerations in 22 months, which may not sound like a lot, and frankly probably isn't a lot in a city where we process 40,000 cases a year at this time and used to process 70,000. But if you compare that to the prior 30 years, I think in the prior 30 years there was about 1. So for the 10 exonerations that we've had, there have been another couple hundred where we took a very serious and deep look and decided that they were not appropriate for exoneration. We are not simply in any way interested in letting out guilty people. We are interested in exonerating people when we find that the case is so lacking in integrity that we cannot justify someone remaining in custody anymore. In some of these cases, there has been the most outrageous and egregious prosecutorial misconduct you can imagine. And that is one of the reasons that DA's offices and chief prosecutors' offices tend not to want to exonerate, because often they did it. And they knew what they were doing when they turned on the shredder or crumpled up the paper or threw it out the window or whatever they did. Some of these DA's offices, for example, the Philadelphia DA's office, especially in a particular period of time, which would have been early 80s and in the 70s, if they knew what Brady was, they didn't want to know. And we know this now because when the police kept their books, they would keep witness statements, and those witness statements are often still there, although they not only were never turned over, but they are mysteriously missing from the prosecutor's file. There's no explanation for why you would be destroying and refusing to turn over exculpatory materials as a prosecutor that existed in the police file of investigation at the time. I can give you one example, which is particularly heartbreaking and egregious, but there's a person we exonerated this year whose case was tried, and tried twice, because it hung the first time, without a couple pieces of paper being turned over. One of those pieces of paper was a report by a detective naming a different suspect as someone the detective believed might be the perpetrator, and explaining a motive for why that other suspect would have done the killing, which was a shooting in a war over turf. The man who was convicted was not in a rival drug gang. In fact, he was a friend of the person who was killed and was first seen by the police crying over the body of the man who died. That guy sat in jail for over 20 years. And the document explaining about this drug war and this other suspect was never turned over. The other suspect died 6 months after the homicide in the same drug war, which further corroborates the possibility that what was going on here happened this way. There was never a motive whatsoever for a person who sat in jail for 20 years. Well, that is utterly unacceptable. It is arguably a crime to have refused to turn that over. And the thing that is so amazing and so brazen about all of it is that the attorney who did it, who even though the inferences are mountainously big, probably could have claimed, well, I never saw that document. Somehow it never made its way to me. That attorney told the Philadelphia Inquirer that he did see the document, that it wasn't Brady, so he didn't turn it over, right? I mean, that's the culture you're dealing with. That's the extra super 175,000 pounds of stupid we're talking about, where you even now still think you can rewrite what Brady says, and you even now think it's okay to say, sure, I saw that. They don't get that. In the mind of that prosecutor and many other prosecutors at the time, if they were trying to play fair at all, which I don't think a lot of them were, but if they were, in their mind, Brady is only something I turn over if I believe the person's innocent. And that is most definitely not at all what Brady is supposed to be. So, yeah, we kind of sort of figure the Constitution is real, and when you take an oath to uphold it, you should, and Brady has words in it that you should read and understand and that you shouldn't cheat. But let us also understand we are in a country where our current president still thinks the Central Park Five are guilty. Never mind, they actually caught the real perpetrator and connected him by DNA. Never mind that, they're still guilty. They should still be killed. I mean, what do you do? What do you do with people whose approach to criminal justice has zero interest in the truth, zero interest in a fair view of evidence, and zero interest in fact? People like that just don't belong in DA's offices. They frankly don't belong in the practice of law. So every now and then you show them the door and you reverse what they did, and maybe you do some other things.
Speaking of the spirit of Brady, D.A. Krasner, and one of your planks in the platform that you ran on that got you overwhelming support by the voters of Philadelphia was addressing police misconduct. Many prosecutors around the country continue to call police officers to the stand who have histories of not telling the truth on the stand. And I know that not all prosecutors are in lockstep with that particular approach. Your office in particular has taken a more principled tack. Could you talk about how you address the problem of officers with a history of not telling the truth, especially when so often DAs have to work with officers in order to secure a conviction, so they're often more like colleagues than just like separate employees working for different branches of the government. But how have you addressed that?
So we have a list. And let us understand, there's 6,500 active police officers in Philadelphia. And in my opinion, the vast majority of them are basically just trying to do a good and honest job. Some of them are remarkable, principled, wonderful people. But there are a few who are not. As in my profession, as in all professions. The former chief prosecutor in Philadelphia is in jail. He's doing a 5-year federal sentence. He should. He's a criminal. He belongs there, right? Well, every now and then there is a police officer who also, should not be allowed to testify and maybe should have some other consequences for the acts they engage in. We have an excellent head of conviction integrity at our special investigations unit who used to run the same kind of a unit in Dallas, Texas for some time, and we persuaded her to come to Philadelphia. She runs the unit now, and we've expanded that unit from basically a person and a half to what's closing in on about 10 people to do conviction integrity work, which has given us the capacity to do these exonerations, but also on the police prosecutorial side, the special investigation side, to construct a list of police officers who either are so troubled that they should not be allowed to testify, or are at least troubled in ways that require us to disclose some information to the defense, because yes, we actually believe in Brady. It's not just that we believe, we follow the law, and we gotta do that kind of stuff. And then there are others as to whom we collect some information because we're seeing problems, but not anything that the Constitution requires us to turn over as yet. It is a list that changes all the time. For example, you could have someone on there who has been convicted of running a criminal organization. Yes, this does actually happen. Police officer. You could have someone on that list who got indicted and taken down to federal court for massive corruption in narcotics cases, but was acquitted, right? Nevertheless, the feds found at a level of probable cause that this person was engaging in massive corruption. They're on the list. We have to make a decision. Do we let them testify or not? Obviously, if they testify, we need to disclose everything we know. You may have people who have not necessarily been associated with a crime, but have been found to lie during the course of an official police investigation. And sometimes that is righteous. They really did lie. And sometimes it might just be that internal affairs is picking favorites. And they're taking what is probably more like an honest mistake, but they're doing somebody else's bidding by taking a shot at a particular officer. These are the kinds of things that we have to work through and suss out and try to be fair and honest about. And we also have to allow that the police officers can get their 2 cents in, that they can come and say, I don't belong on that list. You don't understand what really happened. This is why. Or more to the point, the lower internal affairs process in the department said I did the wrong thing, but the higher level said that was wrong. And then we have to evaluate what we have there. So that is, it takes a lot of work, takes a lot of time, but that's what we do. And we've managed to match it up to our charging process so that when we bring charges based upon police information and Officer Troubled's name pops up, there are automatic notifications that go to the prosecutor who has the case, that go to the file, so that we are not waiting to figure this out. In some cases, we won't even charge because we see that the only witness is someone we would never call. And if the only witness is someone we would never call and we see no other potential to be able to prove it, we may not charge it at all. Or if we do see those kinds of problems, we may engage in additional investigation in other ways to try to establish the case because we know we can't rely on that witness. Well, in the same fashion, early in the process, we're not going to try to get a guilty plea out of somebody and then later they'll find out that we had information on a witness. We're going to give the information on the witness. If we're going to call that police officer and there's some issues there, we're going to give the information. It's going to be part of any negotiation. It's going to be part of any decision about trial. And it's going to at least provide the opportunity for the defense to argue to the judge that this information should be used during the trial, and then we take our position. We agree or we don't agree, depending upon what the information is. Not all these calls are easy. I'll give you a tough one. Police officer off duty on vacation in another county is arrested for driving under the influence of alcohol and is put into the same diversionary program pretty much everybody else gets, completes the diversionary program, and that case is over in another county. Do you turn this over? I think most people would probably say, no, it's not cream and falsy. There was never a conviction. But what happens if that officer is then testifying in a DUI case and says on cross-examination to the defense attorney, gee, I wouldn't know, counsel, I've never been arrested. Well, that door just got kicked wide open, didn't it? And that not only should that never have been said, but now it is totally valid to impeach off the fact that this police officer was arrested, and not only arrested, but arrested for exactly the same type of case, right? So there's a lot of aspects to this that are not straightforward. They are not simple. There's a lot of shades of gray. Nevertheless, we have a structure that never existed before, which is that we actually try to comply with Brady. We try to keep up with exactly what's happening with particular officers, and we have an automatic process within the office that will electronically notify individuals, notify the file, provide the material so they can be turned over early in the case.
Right. A common slander that's leveled against progressive prosecutors, those who are seeking reform, is that reform-minded prosecutors don't show sufficient care and concern for victims, that they aren't concerned enough about vindicating the interest of victims. And I've had to think about this a lot with I had two sons who attended SC here. My oldest, from Viterbi School Engineering, was having a party, and one of the people who was wound up at the party wasn't invited, wound up taking something from a roommate's backpack, and was caught. As he was going out the door, he pulled out a Saturday Night Special and squeezed off a round. My son is standing here, his roommate is standing here, his roommate caught the bullet. It's now lodged in his chest near his heart, too close for them to take it out. Fortunately, he's still doing well. Fortunately, he's pumping, he's running every day, playing ball every day. But I think about how close a call that was to my own son, and it's really heightened my sensitivity to an understanding of what victims of crime go through a lot. And I know that's something you talked about last year when you were here, and I'd like you to share what your office does when it comes to those kinds of issues, addressing victims' concerns.
So we get criticized a lot, and we do more than has ever been done. And I'll talk about both aspects of that. So, for example, we were able to pull off something that no prior administration did. We got $1.5 million to set up a network of 12 people around the city to assist families when there is a homicide in the family. They go immediately to the home, as immediately as the police will allow, and they essentially hold the family's hands for the first 45 days into that process. This is kind of a big deal because the family often doesn't have money for a funeral. They need to fill out paperwork quickly to get it funded through the state. They have to go and identify the body of their loved one. Just the process of getting in a car can be tough. And they often have to be a way to communicate with detectives who are out there and are vigorously trying to find out who committed this crime. Often are frustrated because the clearance rate in many big cities is only about 40%. In Philadelphia, it's in the 40 to 50% range right now, right? And also these folks have to try to make sure the family has access to trauma treatment and has access to things that will keep them safe, because witness intimidation is real. Killings of other family members or threatening other family members, all of that stuff is real, especially when you're dealing with conflict between two groups. So nobody ever did that before. We do it. But we do some other things that are, frankly, more upsetting to some victims and some victims' groups. The first of those things is we tell them the truth. So, for example, if you have a case that is not really a first-degree homicide, and there are 5 levels of homicide in Pennsylvania, there have been 5 levels of homicide that have developed over hundreds of years of jurisprudence. If you say, well, this is a homicide, but it's actually a voluntary manslaughter, which is the 4th level, not the highest level. So we're going to charge voluntary manslaughter instead of first degree. That's something prior administrations would not do. They would charge the highest level, and then they would let the jury or they would let the judge knock it down. And then rather than be honest and say, yeah, well, I kind of misled you by making you think this would be a life sentence. I kind of misled you by suggesting there might be a death sentence. There was never going to be more than a 10 to 20 year sentence. Rather than do that, what they would do is say, oh, that judge is nothing but a defense lawyer in a robe. Oh, these juries, they're just full of dummies. These dummies did that to you. Well, why would they do that? I'm sure is the question you're asking. They did that because they pandered and they lied to victims' families, so the victims' families would deflect their blame onto anybody but the prosecution, because the prosecutor was all about the politics. They were all about the headline. They were not so much interested in the welfare of the family or helping the family. Frankly, they were interested in the headline. That if anybody's getting blamed, it's that judge, it's that jury, it's never the prosecutor, and you never have a family saying, I'm upset because this prosecutor wouldn't follow the most serious charge. Well, we don't do that. We actually tell them the truth up front about what we think the charge is. We tell them the truth when we feel that we have to drop a case. There are some specific cases I'd like to talk about, but frankly, they're not quite done yet. But it's real. When you try to be honest with people like that, you're going to take some heat. Now, the other side of it is this. They would like to tell you that all victims want the same outcome, and it's always, the death penalty, or it's always 1 million years. That's really not true. We had a case not so long ago with a vicious stabbing by someone in the back of a cab who repeatedly stabbed the neck of the cab driver, and we actually had photographs of this whole thing, video of this whole thing, because there was a video camera in the rear view mirror inside of the vehicle. The man who was doing the stabbing had a pretty bad and violent record, and we contacted the victim of the stabbing who said, I don't want him to go to jail. I do not feel it does any good. I don't want him to go to jail, right? Well, we actually pursued jail because we felt differently than that. We looked very carefully at his record. We looked at what we saw there and considered his opinion, just as we consider the opinion of people when they say, I want 1 million years for retail theft. We considered that opinion, but our independent judgment has to be based on pursuing justice for everyone. And justice for everyone is defined by the scope of what you cover. We cover a jurisdiction of 1.6 million people, and we represent the Commonwealth in Pennsylvania, or they would probably say the state in most places. Well, who is the state? You are not ever the lawyer for the police. You are not ever the lawyer for the victim. You are not ever the lawyer for the defendant. You are, in fact, the lawyer for the victim and the defendant and the witnesses and all the people who have absolutely nothing to do with those proceedings. More specifically, the little girl in a public school who doesn't have enough money in her public school because you spend it all on locking up people forever for retail theft. You represent all of those people, and it is your ethical obligation to balance that. I cannot think of any better thing that we can do for victims than prevent there being other victims. And I don't think there's too many victims who would disagree with you on that one. So yeah, it's a real decision about whether a particular crime should be 2 years or 5 years or 50 years. When you understand that what goes hand in hand with that decision is the resources to support that sentence of incarceration at, let us say, just say roughly $50,000 a year. So 50 years is $2.5 million. And 10 years is $500,000. And 2 years is $100,000, all of which could have been expressed in years of a teacher in that public school, potentially preventing another crime like this in the future that might happen. It is difficult because we do have a criminal justice culture in the United States fed by many of these factors, including the media, which is mostly about revenge, and it's mostly about punishment. And it's a real question. Is that your function? Are you there to punish? Are you there to get revenge? Are you there to act like a member of a gang? Is that what you're there to do? Or is your obligation to seek justice one where you are trying to achieve public safety and you're trying to achieve other goals that are not served by this notion of punishment, but they are served by this notion of prevention? Sometimes that prevention might mean a life sentence because somebody should never get out of jail. Mr. Bundy is dangerous. Sometimes that is what that means. Sometimes what that means is you're going to divert a case where someone possesses a gun because you know all the harm that will go with the conviction, and you see a pathway to this person being more likely not to be involved in crime if they are held accountable but avoid that conviction. These are the tough calls. This is ultimately risk management. And it is not just about being the lawyer for the victims. It is not just about revenge. It's about managing risk so that you prevent future victimization of people and you heal society in other ways. That can be a tough message for people who are going through incredible grief, whose lives have, in some cases, been changed forever. Let us not forget that the family member of someone who has been killed would never be permitted to be the judge on that case, would never be permitted to administer a sentence as a judge on that case, and would never be permitted to serve on a jury in that case. That's the law. That's not my opinion. But that's the law because the law recognizes that those individuals are so emotionally traumatized, have been hit so hard by this event that they cannot be fair. So what do we do then? Take people who have been so traumatized that the law says they absolutely cannot be fair and do exactly what they tell us? Or do we do what our ethical obligation is, which is to seek justice for everyone and hopefully prevent this kind of crime in the future? And I will pick the latter.
Yeah, Krasner, you adverted to the low clearance rate, the woefully low clearance rate when it comes to, say, some homicides in many big cities, and other serious crimes. And I wonder how that connects to the enforcement priorities of some departments, both police departments and DA offices. I know that the black community, for example, that I live in and that I've been working in for the last 20 years, wants clearance, wants those homicide cases to be solved. They want the serious crimes to be solved. But often we're spending a lot of our enforcement resources going after joints, going after quality of life, broken windows kinds of infractions, and we wind up with things like rape kit backlogs. When I hear rape kit backlog, I hear a major problem with the enforcement priorities of law enforcement in that arena, because somebody has been warehousing these rape kits rather than processing them while they're over here prosecuting all these turnstile jumpers and going after all of these broken windows, quality of life kind of issues. Could you talk about how your office has grappled with and come up with its own enforcement priorities, and how you're trying to address those more serious crimes and perhaps not divert as many resources toward the more quality of life ones?
Sure, and just so you understand how important this issue is, we like every other jurisdiction, had a rape kit backlog. It was, I think, a couple thousand. I don't take any credit for this because other people got the money to solve it, and it's been going on for 2 or 3 years. When they finally got through that rape kit backlog, there were about 120 unsolved rapes that were solved. 120. And some of these were solved from 10 years before, 13 years before. Some of these were stranger rapes from 10, 13 years before. Can you imagine the impact of having looked the other way and not spent your time on that DNA testing 13 years ago? Can you imagine how many other people that perpetrator was capable of having attacked at bus stops or on some running path or whatever it may be in the interim? You know, that is what you give up when you spend your time prosecuting people for possession of a joint of marijuana, or when you spend your time prosecuting sex workers. Our office essentially does not prosecute sex workers at this time. Our office does not prosecute people for possession of marijuana. That is a ticket for about $25 if the police choose to give it. That's handled in a civil frame. We have moved to the point, we have such a serious drug problem in Philly, and I am so acutely aware of the failures of the drug war, where we're at the point when there is an arrest for mere possession of any kind of drug, including fentanyl, heroin, cocaine, crack, whatever it may be. We divert those cases. We send them all in the direction of some level of access to treatment, some level of accountability, but trying not to get a conviction against those people because it serves no purpose. The only thing it does is disqualify them from higher education, apartments, and jobs. When what they need most of all, if they're able to get if they're able to address their addiction in a way so that they can be employed, or they're able, hopefully, to get past their addiction, what they need most of all is to get those jobs and to get back into that life, as opposed to being burdened by that conviction forever. So we don't do that stuff, and we got resistance. And once again, if you think it was really ideological between us and, let us say, the police union, no, it wasn't. It was overtime. They were making a lot of money for busting people. I mean, honestly, I think if you were to tell the leadership of the Fraternal Order of Police that you could arrest people for having butterflies, in their yards, then they would say, oh, overtime. Or maybe you could arrest them like they did in Ferguson for having your grass too high. Oh, overtime. We can make some money off of that. What happens in Philly is if you go to court to testify and you're not on your shift, you make, especially if it's late notification, quadruple overtime for going to court, whether you're called to testify or not. The longer you sit in the hallway, the more bank you make, right? So, we're talking about tens and tens of millions of dollars. The average amount of overtime for Philadelphia police officers is about $10,000. And there are some police officers who make more on overtime than they do on their salary because they are prolific, which sometimes means they're really, really good active police officers, and sometimes means that they will cut corners and make up facts to make more arrests so they can go to court more often so they can make more money, right? So this is part of the problem, is when you have profit in policing, just like when you have profit in prisons, the whole system is going to get off kilter, it's going to get off the rails. And so you have that whole aspect of it, that we should be spending our time on the homicide cases, on the rape cases. Instead, our resources are spent for reasons that are not justice reasons. They're spent on these other things, these little offenses with police racking up a bunch of overtime, for example. But that's only part of the problem. The other part of the problem is that a lot of dumb stuff has been done for so long, like illegal stop and frisk, like over-enforcement in neighborhoods that are black and brown, neighborhoods that are poor, for so long that there is a lot of distrust, there's a lot of cynicism about how the court system, the justice system doesn't work, and therefore we cannot get witnesses to help us to prosecute cases and prosecute crimes. We had a bust last year, which I think is really instructive. 59 shootings committed by a group of 9 people, 3 homicides, one of which we could charge, committed by this group of 9 people over a period of about 15 months. This case was put together without a single witness. We could not get one witness to 59 shootings, 3 homicides, not one witness to say, I saw Joe shoot the gun. The case was done entirely by tracking 2 things. Number 1, the geolocation of cell phones, okay? Number 2, when you fire a semi-automatic weapon, the projectile goes at the front, maybe what you call the bullet. It's actually the part that goes into your body and hurts you. And a piece of brass comes flying out the side of the gun, which is the part that contains the gunpowder. It's called a fired cartridge casing. Well, when that comes out and lands over there, there are unique markings on them, on the back, that can be tested against other ones. It's sort of like a fingerprint. Not always accurate, but sort of like a fingerprint. We had to do this case off of watching how certain phones went to places where matching brass showed up, and then the same phones went to other places where matching brass showed up, and then we connected that to retaliatory activity between different groups, and eventually, using various things they posted on social media and putting it all together, we had a solid indictment against these folks. Think about that. How the hell did we get to a point where we cannot get a single witness, including witnesses who were friends of the people who got shot, to assist with us? And the answer is, so much time was spent humiliating mostly young men, mostly of color, in broke neighborhoods by doing illegal stop and frisk that anybody who studied this knows 49 out of 50 times those humiliating searches turned up nothing. In Philadelphia, 399 out of 400 failed to turn up a gun. 399 people humiliated for one gun is what that resulted in. When you take that and you layer it on to other aspects of the system, the over-incarceration, the mass incarceration, the cheating on Brady, putting people back in jail, as happened to Meek Mill for the flimsiest reasons when they have committed no new crime, but the judge is simply ticked off. All of that comes together in a way so that the people who are supposed to be served by the police do not wish to engage with the police, do not wish to be witnesses, fear that if they become witnesses, the police will turn on them and claim that they are the perpetrators. When you get to a point where the system is at dysfunctional, unfortunately, you cannot solve crimes. And you also often cannot win juries. Because when juries distrust you in the same kind of way, then why should they listen to your prosecutor? They know Central Park 5 happened. They know that some prosecutors don't turn over all the information. They know that there are some police who lie some of the time. So their standard of proof becomes much higher for them to be persuaded that you're doing something legitimate. None of this harm was necessary. None of it had to happen. What had to happen a long time ago was simply that people would be fair and they would be even-handed, whether you were rich or poor, powerful or not, black or white. They would be even-handed, but it didn't happen, and we are paying the price for this. And so, this is part of the mission of progressive DAs. that you have to reverse that for this system to function properly, for those clearance rates to go from 40% to 60% or 65%. You got to reverse that process. There has to be a restoration of trust, or we're just not going to get there.
I can't stress how important this is in terms of some recent reading I've done in the empirical literature about the relationship between the moral credibility of law enforcement and increases in crime. And they're demonstrating that it does increase crime significantly when law enforcement loses its moral legitimacy and moral credibility. That's so key. I'm going to start opening this to questions in one moment from y'all. I want to ask one more question, and it's the comparative one about your travels abroad, and this we may be able to bring in Miriam Krinsky because I keep up with what y'all are doing on social media, and it's fascinating to me to see what a comparative perspective can bring to our understanding of our own legal system. Sometimes you need some kind of perspective like that to see how out of whack your own system is. You know, when you're just swimming around in the water, you don't know what not wet feels like, right? You never get to leave that element and look back and critically reflect on what you've been doing all this time. So I'm hoping that you can share with us any insights that came from your travels abroad and looking at other criminal justice systems and how they approach blame and punishment and public safety and policy in that arena. And hopefully Miriam Krinsky can also share with us, who I just appeared on a panel with for the League of Women Voters last week or the week before, and she's another one of my real guiding lights in this area. I listen to her whenever she talks about these matters, and I learn every time. So I'm hoping that the two of you will be able to share what you got from those travels.
You want to go first?
Well, thanks, Jody. And can you all hear me? You know, I first of all want to thank you and all of you here, the students, for recognizing this incredible moment that we find ourselves in. And my organization, Fair and Just Prosecution, has the privilege to work with elected prosecutors around the country like Larry. And this really is a very different moment. And we are trying through a summer fellows program, and I have some information here on that program, to find law students who want to be part of this movement and to put them into progressive prosecutors' offices around the country with the aim for them to have a place to spend the summer and also to work on a policy project, so to be part of a policy reform effort. So I will leave some of these sheets here. I think in answer to your question, we have to recognize that the U.S. is this incredible and embarrassing outlier in the world. We incarcerate more people at a younger age for longer periods of time than anywhere else in the world. And they simply can't understand what we're doing and why we're doing it and why we failed to realize the absurdity in what we've been doing for so long. So we brought a group of prosecutors, Larry and others, to Germany to see a different starting point around how they treat juveniles and young people. They simply don't criminalize at a young age. And when they do, they often recognize what brain science and so much else tells us, that until you reach the age of 25, with apologies to those of you who aren't at that age yet, your brain is still continuing to develop, and we shouldn't hold you fully accountable for the stupid things that you do and criminalize you for those things. So we wanted to bring elected prosecutors there to see how they treat those individuals, a rate of incarceration, the fact that they don't have a death penalty there, and recognize that in their mind, a long sentence is 10 or 15 years, not these mandatory 20, 30, 40 life sentences that we've been imposing here. We also brought a group to Portugal to see a different starting point around drug policy. And Portugal is not the perfect finish line in our mind, but it at least has approached drug policy at a time in Portugal when people were dying in droves, a time that, unfortunately parts of Philadelphia are seeing now, and realize that unless we treat a public health problem with a public health response, we're going to continue to see people die. And so our aim was to try to bring that starting point to how we think about issues around, are we going to criminalize not just marijuana use, but simple possession and drug use for all drugs? Are we going to allow people to die without safe injection and safe consumption sites? Are we going to continue to suggest that something that is a public health problem can be incarcerated out of? So our aim was just to see different thinking in regards to those issues. And I know that Larry's doing a tremendous amount in Philadelphia to move on those issues, but really to try to help spur reform throughout the country with this amazing group of new leaders who are open to different ways of thinking about things.
I think she covered it pretty good.
Yeah.
I mean, very, very quickly, every single person in Germany is considered for parole at year 15, no matter what they've done. In the prisons, you don't wear prison clothes. You wear your own clothes. You decorate your own cell, which looks more like a room. They pay you to be educated certain ways, and they pay you to work, as opposed to giving you 3 cents an hour like they do in the United States, because the whole point is to reintegrate you into society so you will not come back into jail. That sort of sounds like a way of stopping crime to me. And in fact, they do this in a place where there's about a ninth, as much crime, about a ninth, as much homicide. So it hasn't actually caused cities to burn, no offense. It hasn't, I'm not trying to make fun of your apocalypse, but anyway, it has in fact worked, and not just there. You look at Lisbon. They used to have 5,000 people dying in the streets, using in the streets, selling in the streets. They now have 1,000, 18 years later, because they stopped criminalizing possession and they pushed it in the direction of a civil remedy and getting people in touch with voluntary treatment. Sorry, it worked. I know it doesn't fit the usual narrative. You got to hit somebody with a stick to help them, but it worked. So I think there's a lot to be learned. Not to mention, we learned that when you don't have a flood of guns, you don't have a flood of homicides. Scotland is now dealing with a spike in homicides. It's a country of 5.5 million people. They have 60 homicides in a year, and they're stabbings. It's a lot harder to kill people when you're using a knife. It takes a lot of effort. It's difficult. So, we do have unique challenges, like the fact that we have more guns than people. And these challenges aren't there. Or we have a unique challenge that we as a country have decided to consume like 75% of the opioids in the world. In other countries, they not only don't let you advertise on television for these things, they don't allow them at all, or they allow them in extremely limited quantities, and they don't have the problems that we have. So we do have unique challenges, but we can't ignore the fact that there's a lot of other countries with 1/10 the amount of crime, 1/10 the amount of people in jail, and systems that are working when they're not working here.
All right, this time I'd like to open it up to any questions from folks who have been sitting in the audience.
Thank you for coming, Mr. Krasner. So you spoke a lot about an obligation to seek justice, and I think there's an easy answer to that question when we're talking about low-level drug offenses, and a somewhat easier answer when we're talking about the death penalty. But I was wondering, earlier in your speech, I was wondering if justice ever looked like 20 years in an American prison to you, or even 1 year. And you kind of gave me an answer to that question in your taxi driver incident. And so my question is, do you think that prisons are actually an effective way of preventing crime? And a follow-up to that would be, if the answer to that is yes, I don't think many career public defenders go into public defense thinking that way. And I was wondering how you think your time in the DA's office have impacted your views about criminal justice.
So I do think Ted Bundy should stay in jail. I think that's a very good place for him. There are a lot of blonde women who are alive because he wasn't out and able to go kill more of them.
Ted Bundy, by the way, for those who might not know, serial killer, serious serial killer.
I would think you would know he was a law student, but anyway. Yeah, I think there are some people, and I don't think it's very many, but I think there are some people who are so dangerous they need to be separated from society. But I do think I'm a prison abolitionist in the sense that I don't really think any prison should be like an American prison. I think if you are going to incarcerate people, then there are much better things that can be done with that time and with keeping them separated from society that are done here. In many ways, I do think German prisons, Germany not being a place with a particularly perfect record during certain eras for civil rights, but I do think since World War II, modern Germany has taken a turn in a direction that favors human dignity, that views jail as not being for punishment, but as being for the purpose of treatment and reintegrating people into society in a way that will prevent crime for others, but will also allow them to live out fuller lives. That's kind of how I think it would be. It may very well be the case that in 2019, a lot of people going into careers as public defenders believe that there should be no jails, there should be no prisons. I frankly applaud that. I hope you're right. There's nothing I'd rather see than I look like a stuffy old conservative in about 20 years. But there's also a lot of people who've been public defenders for 20 years who will disagree with you because they haven't just read about it in books. They've been going into jails and representing clients for 20 years, and they met a few who they think need to stay there. And I say that respectfully. I don't say that in a way to look down or disapprove. I know that there are some people who are truly cut out to be defense lawyers only, and I think that that's wonderful. I did that work for 30 years. I represented tens of thousands of people and did an awful lot of trials. But I also think that there are people who can do both. And to some extent, when we are recruiting, we don't want to take someone away from what is their true calling. If your true calling really is the abolition of jail and always being on the side of the defense, then you should do that. But if your true calling is not that, if your true calling is that you want to serve people who are broke and are black and brown and are charged with crimes and are sometimes guilty of crimes, and you want to actually bring about sweeping change, you're not going to do that in a public defender's office. No offense, but you're not. I was one of those people for a very long time. I did a lot of justice for individuals. I never achieved sweeping change or anything close to it like I've been able to do in the last 22 months during my entire career. When you can get up in the morning and say, when I started, there were 6,500 people in county jail, and now there's 4,600. Not bad for 22 months. You're actually saying something, as opposed to saying, I won my case. There's one less person in county jail today than there was yesterday, which is what I used to do. So I see tremendous value in both of those callings. I just think that a progressive prosecutor, if it's something consistent with your vision of justice, can get a lot more done.
That segues, I want to get your hand next. Very quickly, that segues to one question I think many might have on their minds, and that is what their experience would be like working in your office for the summer or if they do it on a full-time basis. I love Philadelphia. I went to Lower Merion High School on the main line, Ardmore, Paoli Local. I took up the main line, and it was my favorite city on the East Coast by far. If it wasn't for Southern California sunshine, I'd be there. But I'm sprung. I can't leave now. I've been here too long. But what will their experience be like in Philly?
Are those flames I'm seeing through the window on the door?
I know. You got me.
I mean, I do like the heat, but not necessarily that kind of heat. Well, I understand. There's another famous graduate of Lower Merion, is there not?
Kobe.
There we go.
I had 23 a game. I had the record before he came along. 23 a game my senior year.
You got displaced by Kobe?
Kobe.
Man.
He averaged 33, so I can't even bring up my 23.
Well, you had a great career in the NBA as well. So I hear that. What was the question? We were having too much fun. What was the question?
What's their experience going to be like working in your office this summer or in the long run?
All right, so let me give you the fast version of what I think it would be like to either be working in the summer or to be a new attorney. We have a really excellent program for 1Ls and 2Ls. The only main difference is that 2Ls get to actually go to court and represent on cases. They do real trials in front of real judges in misdemeanor matters. You prepare a whole lot of them, maybe 100 or 2, but you'll get to actually do between, say, 2 and 5 cases as a 2L in the summer. There's pretty intensive training, which we spend our time doing, and then you get to go to court and do your thing, but you also get to specialize. So if you have a particular interest in rape cases, for example, and you want to follow around prosecutors from the Family Violence Sexual Assault Unit, go through some trials with them, you could do that. If you're really interested in conviction integrity or prosecuting police officers, you could go to conviction integrity or special investigations, follow them. If you really wanted to hang out with a homicide prosecutor, see a homicide case, help prepare it, sit in the front row, talk to the attorneys the whole way through, you can do that. So that aspect of it, being able to shadow attorneys, I think is very valuable. And then because we go all over the country, because we recruit all over the country, and we get amazing people from all over the country, we understand that you don't know Philly necessarily, and you may be disconnected from your network of people, so we go out of our way to make it fun. We actually have a lot of events, a whole bunch of senior attorneys, whole bunch of interns going to the, should I say it, Phillies game. People might actually gather for beers. There may be a tour to go and see our historic prison, things of that sort. So it becomes very social. There are events all the time, a lot of educational events. I mean, for example, we had James Foreman do a Skype interchange with a bunch of people who read his book this summer who were in our summer program. And it's a big program, about 75 people. We had maybe 30, 3 Ls, maybe 20. Let me try again. 32 Ls, maybe 21 Ls, and then we had some college students who also participated in the program. From that group, we debrief everybody. There are certainly some people who are interested in a permanent position. If they say they are, then we consider them first. Out of our class this year, we gave out over 20 offers, and we have had an acceptance rate that's about 85%, which I find stunning as much as I love Philadelphia. But I think a lot of what happened is they came, they met their peers, they realized that all of these were really interesting people. They had a great summer. They discovered the city, the restaurant life, the nightlife, everything else about it, the fact that it's a walking around city, that it's affordable, and they could see a future there, so they were willing to make a 3-year commitment, which is what we require to becoming a prosecutor in the city. So that's what the 2L thing is like. 1L is very similar, but you don't get to go to court. We will take we take people for either one or the other. We don't let people come for both a 1L summer and a 2L summer. We think they will be better lawyers wherever they are if they have a different type of experience that other summer. So for the people who get hired and start, we just started our first class that was selected by us from this process of going around the country. For the people who start, you're looking at starting right after Labor Day. It's about 8 to 10 intensive weeks of training while you wait to pass the bar. Bar results come in, and you head right into court. And you do a lot of trials. Philly is a place where there are a lot of trials to do. Some people go straight into the law division, but you get a lot of experience trying bench trials as misdemeanors and then as felonies and then doing jury trials within Philadelphia. Philadelphia has what I view as excellent juries. They are very diverse. They're very nuanced and sophisticated. Your average juror in Philly is likely to have a police officer in the family, a person who is doing hard time in the family, and someone who has been a victim of a serious crime in the family. So they're seeing it from all angles. They really get it. And I think that they are capable of being very fair. It can be a challenge for prosecutors who can only win if the jury's unfair, right? But we don't want that. We want to be winning for the right reasons, with the right work and the right evidence, doing it the right way. So it can be a very, very exciting existence, in my opinion. I could, at this point, maybe I will, ask Yasmin. Yasmin Rosario is here. She was not hired by me, but she is a 6th-year attorney who has been here for the last 22 months, now in the Dangerous Drug Offenders Unit, but has previously worked in family violence, sexual assault, done all kinds of trials for a very long time, became a vertical, meaning she handled very serious cases, shooting cases, for example, from beginning to end, rather than having those files passed from hand to hand, which often happens in a large office. I'm not going to put you on the spot too bad, Yasmin, but if you could just give us a couple minutes of what you think it is like to be a district attorney in Philly, and I'll cover my ears. So.
That's not necessary. Hello, everyone. As Mr. Krasner said, my name is Yasmin Rosario. I've been an assistant district attorney in Philadelphia for 6 years. I myself did the 2L internship program, which I thought at the time, and I think still is, one of the most unique programs in a prosecutor's office in the country, insofar as you get to actually take your cases. I probably had at least 20 cases a day that were given to me. I prepare them for either a preliminary hearing, which are felony cases. It's kind of like a probable cause hearing. The judge is determining whether there's enough evidence to take the case to trial, and then you get to do municipal court actual trials for misdemeanor cases. I loved it. I mean, you're really in there having to multitask. You have police officers constantly coming up to you. At the same time as defense attorneys, they want offers. And you really have to field questions from judges at the same time. It's really a unique experience that I don't think you get as a 2L in some places, especially if you wanted to do something corporate or something else. I mean, you're not really going to get an experience like you have in the Philadelphia District Attorney's Office. So, I mean, being a prosecutor is something that I wanted to do after I thought about, the two sides of criminal justice, defense, prosecution. But, I mean, I became a prosecutor because I wanted to do justice and do the right thing. You have to represent everybody. Like Mr. Krasner said, and I've said in interviews, you can find it, I'm not just copying you. That really, the defendants are part of it, the victims are part of it, the entire community is part of it. So our job is to make sure that the system functions fairly, and that's what I strive to do as a prosecutor, and I've really, really enjoyed it, and I continue to. So it's a great program. I would encourage everyone to apply if you're interested in doing good criminal justice work.
I would also like to point out that we welcome people who may never have, an interest in working in our office, people who are experimenting, trying to figure out whether they should be public defenders or maybe work for a nonprofit or should be prosecutors. There's someone here, Eugenia Bagdasarian, who was here this summer, and, in private, you can ask her what she thinks about the whole thing, or if you want to say a word, you can. It's up to you.
Nuts and bolts of what you do during your 2L summer. You essentially take ownership of a bunch of cases after 2 weeks of training. It's very overwhelming at first, but it's a great opportunity to learn a lot. You're basically going to court every day. You're dealing with complaining witnesses, you're dealing with cops, you're dealing with public defenders, you're getting to know judges. It's an excellent opportunity that I think is unparalleled. And then obviously like the city itself, like Mr. Krasner said, is just amazing. Like LA, nothing's affordable. Philly, you go out, no one's like driving, so after work everybody goes out together, and it's a totally different scene. I really enjoyed it. And then your supervisors are excellent. Most of my supervisors were former PDs for like 30 years. And they were so sweet, so understanding. Like any questions that you had, you always felt comfortable going to them, asking them questions.
So I unfortunately need to pop out, but I have left some sheets on our Summer Fellows program here. I thought the question was a wonderful question, and can I just make two quick comments before dashing out? The first is, I do think that as law students, if any of you are thinking of becoming prosecutors or public defenders, I would encourage you to spend some time looking at the prisons and jails and really seeing what goes on in those facilities, having spent some time investigating here in Los Angeles, truly horrific human rights abuses in our county's jails. And I think, and Larry and others, are very committed to this, that no prosecutor should ever advocate for somebody spending time in a carceral institution until they've seen it up close, because that will truly open their eyes. The other thing I would say is that one of the things we experimented with last summer was to have a summer fellow split his summer between a public defender's office and a DA's office. And it was an amazing experiment. It can't be in the same city. He spent half his summer in the DC Attorney General's office and the other half in a public defender's office in Manhattan. And we are now looking for a couple of summer fellows to deepen that. I really believe that you shouldn't be a prosecutor until you've seen the practice of public defenders and vice versa, and that they need to be partners in the pursuit of justice rather than adversaries. So we are looking this summer, we take a small number of summer fellows. I think we had 3, Larry, if I'm not mistaken, in your office. 5, okay. Wow, wasn't intended to be that many, but.
Maybe it was 4.
Maybe it was 4, yeah. Carolyn would know for sure. But we are looking to maybe have a few more fellows. And again, thank you to Jody and to all of you for your interest in this important issue.
All right, I got to shamelessly hustle here for a moment. So we are going upstairs where we have some interviews that we're doing. If there is any 2L or 3L, I don't care what you're wearing, who has been decided to have your soul saved and wants to come on down, we will be in room 110. Do not be afraid to come over in a t-shirt. We're happy to chat with you, a little informational, whatever. We can always set up a Skype interview from afar at a later time, but we're hiring, and we're hiring now, and we're picking 2Ls for the summer program now. And if you have come to understand that you could be part of what is arguably the most important civil rights issue of our time, either in Philly or in some other place, I encourage you, don't miss your chance. We are saving souls. Come on down. We will see you. We have to leave at 3 to go to UCLA to speak there. I'm sorry, but we do. It almost burned down yesterday. We couldn't do it yesterday. So we will be there after this talk and until 3 o'clock. Thank you all.